7 things not to include in your will. So as an estate planning attorney, I do 50-point audits of existing estate plans, and I see a lot of these mistakes over and over again. And the first is private information. One of the biggest differences between a will and a living trust is wills are public when you pass away. In fact, you can go Google some celebrity wills like Marilyn Monroe. The privacy of a living trust is often why a lot of clients choose a living trust over a will. But if you are going to use a will, you don't want to include private information in the will. Things like the details about why you're disinheriting someone. Or if you have digital accounts, you shouldn't be putting accounts and passwords into the will. Number 2, retirement and life insurance accounts should never be put in a will. This is super, super important because for many of us, our retirement and life insurance accounts are going to be our largest asset. And chances are when you got that retirement account or that life insurance account many, many years ago, you had different circumstances. Maybe you weren't married, maybe you didn't have children. So you just put someone down as a beneficiary and didn't give it much thought and forgot about it. Maybe you put a sister or a friend. Well, those beneficiary designations will trump what you put in your will. And this is the biggest mistake I see. So if you do set up a living trust, you want to update the beneficiary designation to that living trust. And if you do keep a will-based plan, you want to make sure those beneficiary designations are with who you want them to be. The third is real estate that you hold in title with someone else. So if you're married, you most likely own the title to your real estate jointly with your spouse. And when you pass away, it will transfer directly to them. Sometimes people, without speaking with a lawyer, jointly own real estate with a son or a daughter, trying to avoid probate. And that has a lot of other issues that we could talk about another time. And then they just write in their will what they want to happen to the real estate. They want 1/4 to go to one child, another half to go to another child. Well, that won't work. When you have joint title of real estate with someone else, it's going to automatically transfer regardless of what your will says. The fourth is your medical wishes and your funeral wishes. The reason you don't want to put these in the will is because it's time sensitive. So often people aren't looking at your will until days or even weeks after you pass away. Now, if you are in the hospital and you want to make sure that your choices are honored, maybe you don't want to be on life support, or you do want to be on life support for a certain amount of time, you want to put that in a separate document. It's often called a living will or an advanced healthcare directive, depending on the state that you're in. It has some different options and you want to lay that out, have your choices known, and give those to the right people. Same with your funeral wishes. You either want to put that in a separate document or let the people in your family know about your wishes. The fifth is a living trust. And I see this problem a lot when people create trusts online and they don't work with an attorney. Anything you put in the living trust will be governed by the living trust documents, not what is written in a will. The sixth is money to care for people with special needs. If you leave them money outright in a will, you may disqualify them from government programs that they need. So you really want to set up a special needs trust and make sure that that money is taken care of for them and doesn't disqualify. And the seventh is money to care for a pet. So pets can't receive property or money outright. If you want to leave money for a pet, you should leave it in the form of a pet trust and then designate someone to take care of that for them.